some of the results of my research. In the next 20 minutes, the presentation will address whether shared physical custody is reshaping joint custody as a legal tool in Belgium, Italy, England, and Wales. The presentation will be divided into three main parts. First, I will provide a brief introduction to child's custody. Second, I will focus on how shared parenting has been implemented in the considered legal systems. And in the end, joint physical custody will be analyzed, paying attention to both statutory law and case law. Let's start with the introduction. Prior to the mid-20th century, legal custody of children was solely granted to fathers during and after marriage, with the family being treated as a legal institution rather than individual family members. The Industrial Revolution and the post-World War II economic expansion brought about a maternal preference standard and later a primary caretaker approach, which granted custody mostly to women after separation or divorce. These ideas were echoed in the legal scenarios by psychoanalytic theories, in particular Bowlby's, as well as Goldstein, Freud, and Zolnit's attachment theories stress the importance of the mother and the primary caretaker, respectively. However, the three considered legal systems have since recognized the importance of a significant and continuous relationship with both parents after the separation and have shifted to a shared custody approach. Even though they share the same ground principles, there are some differences regarding the way shared parenting is implemented. Let's now move to the second part and let's discuss joint custody. These legal systems offer three distinct shared parenting approaches. I will now list them and I will later explain them individually. England and Wales adopt a physical custody-oriented approach. Italy, on the opposite side of the spectrum, is legally custody-oriented. Belgium falls instead in the between. Belgian law indeed reveals a legal custody-oriented approach with a physical custody recommendation. Let's start with England and Wales. The Children Act 1989 abandoned the legal concept of custody and therefore moved towards residence and contact orders. Later, the Children and Family Act 2014 introduced the Child Arrangements Order, leaving the distinction between residence and contact orders behind. Such a reform aimed at decreasing the interparental conflict before the courts, but as you can see on the slide, application for residence orders increased after the reform. Courts issue a child arrangements order instead of custody orders, determining who the child will live or spend time with. Even though statutory law does not use such a terminology, it is common to distinguish between live with and time with orders. After separation, parents automatically continue to exercise parental responsibility. But how do parents exercise parental responsibility within the schedule ordered by the courts? Despite the lack of a specific order in this regard, after separation, parents automatically continue to exercise parental responsibility. Under Section 2, Paragraph 7 of the Children Act, you can read on the slide, those who hold parental responsibility may act alone. However, consent of the other parent is required in certain matters affecting the child. In Re J, Lady Justice Butler's laws emphasize that fundamental decision on the child's upbringing because of their long-term implications on the child's life, should be only carried out where the parents together approve of them, or in the absence of such an agreement, where a court had found the decision to be in the best interest of the child. Moving to the Italian legal system, in Italy, joint custody after separation and divorce was identified as the preferred model in custody cases in 2006. As you can see below on the slide, over 90% of custody orders are now joint custody orders. Therefore, the pre-reform trend was inverted by the reform. The 2006 Act introduced a statutory provision on shared parenting principle, under which preserving the relationship between the child and both their parents is at the core of custody law. Joint legal custody is therefore awarded unless it is contrary to the child's best interest. In such a scenario, parents are expected to exercise the parental responsibilities together in the best interest of the child, and they are also expected to reach an agreement on the terms of custody, upbringing, residence, and child support. Courts should then enforce such agreements rather than imposing their own conditions on the post-breakup family unless it is contrary to the best interest of the child under Article 337 ter of the Italian Civil Code. Once awarded joint legal custody, the child's post-breakup housing regime is determined by the court. This could lead to two main outcomes. More commonly, the court will decide with whom the child will live, the so-called collocatario parent, which means the parent with whom the child will mostly live. The court will determine as well how often the other parent should have contact with the child. The distinction between collocatario and non-collocatario parent have been strongly criticized on the ground that they assume an asymmetrical division of roles and involvement between a primary residential parent and a secondary visiting parent. Another outcome might be the fact that courts might also decide for a joint physical custody regime. According to some, joint custody as introduced by the 2006 reform should be interpreted as a joint physical custody, but we will see that in the third section. Moving to Belgium, joint legal custody was introduced in Belgium under the law of April 13th, 1995. The best interest of the child, in the best interest of the child, parents exercise parental authority together, regardless of whether they live together or not, under Article 374 of the Belgian Civil Code. In other words, parents automatically continue to share the legal custody of their children. Under Article 374 of the Civil Code, courts are asked to determine legal custody as extrema ratio, only in two cases: when the parents are not able to reach such an agreement, or when the parents' agreement is against the best interest of the child. Notably, regarding this last scenario, there is no published case law. In 2006, after years of lobbying, mainly from fathers' group advocating for the recognition of fathers' parenting role, the legislature introduced joint physical custody, and we will discuss about this in the third part, and the right of the parents to have staying contact with the children was also introduced. If both parents exercise parental authority, then the right of contact falls within the scope of parental authority, and it entails the right of the parent to have the child with them in order to care for them. In sole custody scenarios, instead, the non-custodial parent has a right to personal contact with their child, despite they have no parental authority. Since 2018, the judge can only deny the exercise of such right where this is found to be against the best interest of the child under Article 375 bis of the Civil Code. As you can see on the slide, joint physical custody orders are now 4 times more common than before the 2006 reform. However, the mother as primary residential parent is still the most common outcome. Let's now move to the third part and discuss joint physical custody, starting with England and Wales. After the Children Act 1989, case law did not establish a preference or presumption for shared residence. In Reddy, for example, the Court of Appeal explains that the court is to presume, unless the contrary is shown, that the involvement of a parent in the life of a child will further the child's welfare under Section 1, Paragraph 2A of the Children Act. But that this does not mean that there should be any particular division of the child's time. However, courts have the power to grant share residence orders under Article 11, Paragraph 4 of the Children Act. Such orders were initially rare and only granted in exceptional circumstances, such as when parents had an amicable relationship, but also an amicable breakup. Court judgments have since inconsistently followed two main approaches, one that emphasizes the welfare of the child and the other that focuses on the parent's equality in the eye of the law. The third approach suggests that shared residence is appropriate when it reflects the reality of the child's life. In this regard, the leading case was decided in 2001, and it's D versus D. The 2014 Children Act did not impact this approach. So far, we have discussed the aim of joint residence orders, but what does joint residence look like? How is it implemented by the courts? As you can see on the slide, some courts have implemented a literal reading of shared residence. This was the approach taken where a week-on, week-off regime is awarded. Often the order does not pursue an equal nor near equal sharing of the residential time between the co-residential parties. This is the case where one of the joint residential parents was granted 3 days with overnight stays during every other weekend. Joint residence order does not seem to regard the time the child is spending with their parents. Shared residence order is used instead to award the parents with a totem of their role towards the children and their welfare, rather than the factual reality of the child's life. Not only sometimes courts themselves struggle in labeling the time schedule under one label or the other, but also overnight stays are not automatically included in a joint residence orders. If staying contact is considered consistent with the best interest test, then it is explicitly included in the joint residence order. Therefore, focusing on a quantitative aspect, it seems quite difficult, if not impossible, to provide a definition of joint residence under English and Welsh law. Moving to Italy, traditionally the Court of Cassation has rejected the idea that joint custody shall be interpreted in terms of joint physical custody, since the parent-child relationship is mostly dependent on qualitative elements such as the parental involvement in understanding and meeting the child's needs, rather than on quantitative ones based on timing. Lately, the Court of Cassation held instead that children should spend roughly equal time with each parent, except when serious impediments occur. In this regard, 3 main aspects have to be highlighted, and those are the fact that limiting the roughly equal contact regime the parents have agreed on is against the best interest of the child in the absence of a serious motivation. Moreover, a prima facie equal contact principle was introduced judicially. It does not coincide with, nor it is a corollary of, the best interest of the child. Courts are indeed asked to take into account the circumstances of the case and to perform the best interest test when deciding on the placement of the child. The last aspect to highlight regards the fact that courts have the authority to depart from the prima facie principle to protect the child's stability and support their bringing. Therefore, joint custody does not automatically result in a rigidly predetermined parent-child timing schedule. In the last years, some first instance courts have started placing the child with both parents equally. They indeed argue that the parent-child right to maintain the relationship demands an equal placement of the child. In this regard, looking at the slide, we can see how courts have implemented this idea into different schedules. For example, some courts have stuck to a literal interpretation of equality, dividing each week into 2 slots, and each parent has the child over for one of the 2 slots, alternating every week. More commonly, courts opt for a patchwork-style contact regime rather than an alternate week one. We can see how this has been implemented differently by the courts. Some are alternating the days during the week, dividing into many slots. Others are just alternating days on a regular basis. So despite some slight deviations, joint physical custody rigidly sticks to the equal distribution of the child's time according to a 50-50 ratio. Finally, moving to Belgium, Joint Physical Custody Act 2006 introduced the judicial recommendation for shared residence, and in this regard, 3 factors are taken into account under Article 374 of the Civil Code, and those are the circumstances of the case, the best interest of the child, and the interest of the parents. A joint physical custody order can be made under 2 conditions: the fact that parental authority is exercised jointly by the parents, and that at least one of them asked for the order. As far as the second requirement is concerned, joint physical custody cannot be imposed ex officio, even if such regime was found to be the most suitable by the court-appointed expert. However, the court has the power to refuse to make the joint physical custody order when such a regime is found to be unsuitable for the child under Article 374 of the old Civil Code. In this sense, the 2006 reform has introduced a recommendation for joint physical custody rather than a presumption. Even though the family court is asked to investigate as a matter of priority whether this regime can be awarded, family courts shall decide on a case-by-case approach. The shared residence regime might be implemented in different ways. Looking at the slide, you can see how most commonly the child will spend alternative weeks at the home of each resident parent, and the child is usually staying over at the resident parent place from Friday to Friday, with the parent collecting them after school. However, this is not the only possible outcomes. Between the many possible outcomes, the court could indeed grant shared residence on alternative months, or also alternative residence might be developed around shorter periods of stay with each parent, and this is called the split shared residence. So jumping to the conclusion, overall shared physical custody is becoming increasingly common. This trend is taking place regardless of whether statutory law explicitly provides for such an order, or even whether a recommendation was introduced. Such an approach does recognize the importance of direct parent-child contact. This allows the child to maintain a meaningful relationship with both parents after separation through direct contact. However, it carries some challenges. Focusing on the quantitative element only, the very core of shared parenting seems to be overshadowed. Indeed, shared parenting implies parenting together, sharing the parenting experience. This does involve a vertical dimension, the parent-child one, but it also implies an horizontal dimension, the one between the parents. When the timing rather than the shared exercise of the parental responsibility became the main focus, all that remains is alternative parenting instead of shared parenting. Thank you very much for your attention, and I really hope you are enjoying the rest of this really interesting conference.